Those who are to speak for or against the bill. After the, you can pass it around or see if anybody'd like to sign up, Xavier, and that'll be after the presenter of the bill presents his bill to the committee and answers questions, if there are any. Let's see. Okay. Representative Williamson, would you open us up in a word of prayer and we'll begin?
Be happy to. Let's pray. Gracious Heavenly Father, thank you for the gift of this day, Father, the gift of ability to serve you. Father, we just pray for the families here and pray that your will be done in all things. In Christ's name, amen.
Amen. Thank you. Representative Fleming, are you ready to present your bill?
Yes, sir.
Okay, we'll proceed.
Thank you, Mr. Chairman and members of the committee. Good to see you today. House Bill 441 deals with trust law, an extremely exciting area of the law. Guaranteed to put you to sleep if you read it too long. But it actually is an important bill because the goal of this bill is to keep Georgia up to speed with other states that are adopting revisions to their trust codes as it relates itself to how you can invest money in the state of Georgia. Y'all remember where we passed the tax relief for our manufacturers, where we don't charge them income tax on sales tax. Y'all remember probably every year, every other year, we have a bill that comes through that keeps our corporate code up to date with Delaware so we could be competitive with them. This bill, House Bill 441, I put in that same range. It's attempting to keep us up to date with other states as they make changes to their trust law. As y'all know, what a trust is the ability to take property, assets that you own, put it into a trust, and that trust then benefits somebody else or possibly yourself under this bill at a later time and date. Traditionally, in trust law, what you will do quite often is I have 3 children. I don't want them to inherit the money I have until such a time as when they reach age that I think they can be responsible. I put that money into a trust, or I want to set up a trust for my grandchildren. And then the trustee, which is quite often a large financial institution, will make payments to that person. One thing that is happening around the state now is that we're allowing self-settling trust, if you will, for lack of better terms. And that is that one of the beneficiaries can be the person who puts the money into the trust, the settler himself. And that's what the goal of House Bill 441 does. Not quite 20 other states now have some version of this. And what it does is that if you're a person in Georgia who has been successful and you have some assets, you want to put it into a trust to benefit your children, but you also wanted to use it maybe like somewhat of a retirement fund for yourself, you can't have to go to another state to do that. You have to go to Tennessee to do that. We'd like for those investments to stay in Georgia. We'd like for our financial institutions in Georgia to be able to take that money that you set aside as a trust and the investments go into our community, because we all know what trustees do when you give them money is that they invest that money quite often in the local community. The accountants, the attorneys, the investment folks that work on this, we want those all to be Georgia people. And that is basically what the goal of this self-settling trust bill does, keep us up to speed with several other states, almost 20 now around the nation. Mr. Chairman, that is a brief overview of the change that is made to our trust law and HB 441, and I'll be happy to try to answer any questions of the committee.
Yes, and we certainly want to give everybody a chance to ask questions. We are in a bit of a time crunch, so let's be succinct if we have any, but we'll take as much time as we need. Representative Williamson.
Thank you, Representative Fleming. I'm not an attorney, and you are a scholarly one. I know that I have set up trusts for the benefit of my young children. It was basically to protect them from themselves.
Sure.
Until they age majority, prove that they will be fiscally responsible and be able to handle their affairs in an orderly and in a good manner. So, and I just in my naivety as a non-lawyer, I thought that's the way all trusts work. And what's the purpose of the trust if the grantor in this case can get the money directly back out?
Well, the grantor in this case could not completely get the money directly back out. That's part of the point. There has to be another beneficiary besides yourself, and that's why they use the example of yourself and your children. But, I would say it's wise retirement planning. We encourage people every day, whether you're in state employee or work for a private industry, to put aside that portion of your income for a rainy day or for when you retire. And that's absolutely what it allows you to do in this case. And the point being that if you have been a successful businessman employing people in the state of Georgia, we want you to think about not only their retirement but yours. But the key thing is they can do this in another state. We just want them to do it in Georgia and not take the money elsewhere. Does that make sense? And maybe I didn't understand your question.
Follow-up question. So, and again, I want to make sure I understand it where we can help the bill move on, but I've been involved in a banking background as
Sure.
well, as far as being a bank investor, and I think just to make it clear, it's my understanding that this would not affect creditors' rights.
No, it would not.
And I just want to make
Yeah, there's nothing different than this trust than any other trust under current Georgia law, and that is you have to, anything you put into trust after you owe somebody money would be subject to the Fraudulent Transfer Act. And in other words, under Georgia law, if under current trust law, if I set aside a large sum of money for my kids, but I did it after I had taken out notes, that money's still going to be subject to my creditors. So nothing about this changes that. Yeah, if I think I understand your question directly.
that is my question, and follow up with just one more, Mr. Chairman, with your chairman's permission. So we're thinking, that answers my question about creditors. Would this type of trust provision not also grant the trust, the beneficiaries of the trust, the protection against unexpected losses, for example, uninsured losses. It could be court verdicts from anything from automobile accidents or uninsured losses, like it could come at one from, for example, environmental claims that aren't protected by insurance or things of that nature. So would that not give them a mechanism to protect assets, not where they fail to pay a creditor under I promise to pay scenario, but where a court came at them with a verdict that was uninsured?
I think you're absolutely correct, because that's what current trust law does. When you if I've got $20 in my pocket and I take it out and I give it to Jeff, it's no longer my money. It belongs to Jeff now. In the situation with a trust, just like you're describing, once I transfer my property out of my name, even though in this situation where I may eventually get some of it back, it no longer is my property and no longer subject to the things that you're talking about. And whether you do it to protect your kids because they're going to blow the money at an early age, or you do it for retirement purposes for yourself, it's putting money away just like we do in many other areas of the law. Many of you are familiar with Social Security benefits. Social Security benefits cannot be attached. You can't take someone's Social Security benefits away from them with a garnishment, for example, in the state of Georgia. Many pensions are protected the same way. You know, the way I look at this is a fancy way of buying an annuity. If I buy an annuity from any person on here that sells insurance, what am I buying? I'm buying steady payments to begin probably at some point in my life. It's a retirement situation. I no longer have control of that money. I have given it away. I bought an annuity with it, and I will be getting something back from it, but it's no longer my property. All I'm insured is a payment. And that's something very similar that I think a self-settling trust would do. And like I said, we're not plowing new ground here. There's almost now 20 other states that are allowing some version of this. We're trying to make sure that our citizens in Georgia can go to SunTrust Bank or Wachovia or the local bank around the corner and allow that money to stay in our community first, versus me having to go to Tennessee, who does it right next door.
The final comment then, if it does, there's no fraudulent transfers allowed.
Correct.
Which you said it is, and it does allow one to protect from unexpected
Like any
claims,
trust would, yes.
then it sounds like a good plan to me.
Thank you, Ms. Williamson.
Mr. Vice Chairman.
Yeah, let me make sure I understand this correctly. In this trust scenario, it will be the trustees and yourself if you're setting up the trust. Is that what you're saying?
Make sure I understand your question.
You're
Mr.
talking
Hawkins.
about you can be among the trustees, the person setting
No,
this
no,
trust?
no. You can't be a trustee. You can be
Okay.
a beneficiary.
Okay,
Yeah.
all right,
Yeah,
All right.
yeah. Somebody else,
Right,
under
that's-
trust law, and this doesn't touch that, somebody else has to
Right.
be the trustee.
right, okay,
Yeah,
good.
and like I said, many times with people who are planning like we think they will, we're talking about large financial institutions that do this day in and day out, professionals, and do a good job at what they do.
Right, okay.
Representative Williams.
Thank you, Mr. Chairman. Representative Fleming, let me follow up on the line of discussion that you and Representative Williamson were having there about creditors' rights and fraudulent conveyances and whatnot. In looking at the bill, lines 139 to 141 talks about a settler shall know, if a transfer of asset has occurred, a settler shall notify all of his or her known creditors. I'm just curious about sort of, again, as a non-attorney, what that means and why that's in there, if there are really no implications here for creditor rights and the issue of conveyances of assets and or collateral. Can you speak to that?
Belt and suspenders. Not only is current trust law in Georgia says that once I owe somebody money, I can't put it in a trust and protect it. That's current law in Georgia already. This simply is one more added protection that not only is that the law, but you've also got to notify them. And to that point, Representative Williams and Mr. Chairman, what we did is we went to another part of the Georgia Code that had those same requirements, and I have language at the appropriate time, if the committee so desires, to even improve that language more. I've got an amendment, basically. Does that make sense, Representative Williams, to answer your question?
Thank
you.
Uh, could you speak to that amendment since he brought that
Sure.
up?
We went to another part of the code that currently has this in there, and if you were to strike lines 139, 140, and 141 and replace it with the following words: within 30 days of transferring an asset to a qualified self-settled spendthrift trust, a settlor must give notice by publication of such transfer in the legal organ of the county of residence for his creditors. The reason we took that from another portion is that you do have a little bit of trouble there of saying who your creditors are. And if we're putting this in just as belt and suspenders, we didn't want to cause more problems than we created. So it would be publication by notification. Actually, that's probably not even needed. It was put in there just as a safeguard to make people feel better about the situation.
Mr. Duncan, I believe, was next.
Quick question here. I'm just trying to figure out the problem that this is solving.
Sure.
Because I have other vehicles and resources at my fingertips for, retirement and savings and
Sure.
and assets. If I understand that the basic premise behind the trust and other generations, but I have tools and resources to use to invest those dollars. What does this do differently than those other resources that are out there?
It keeps us competitive with other states that are allowing this. And right now, if you're one of those people that want to use a trust as a planning tool, you cannot do this in Georgia. You have to go next door to Tennessee. So we have our trust law in Georgia, which is somewhat similar to many other laws in the nation, where we allow people to do this kind of planning. If we right now outlawed all trust in Georgia, you would see assets leaving the states to go to banks and other places and where state laws that could do it. So the need for doing this and the problem we're solving is that this is allowed in many other states, and it's the trend. It's not allowed in Georgia.
So the problem it's solving is it's expanding the definition of a beneficiary.
No, beneficiary is
It's
still the
adding
same.
to that list.
Beneficiary is still the same under the law. It now allows a beneficiary, the settlor, to be a beneficiary, like other states
So
are
that's the
allowing.
expanded part of that definition.
That would be the change in the law that this bill would bring. Yes.
Thank you.
Mm-hmm.
Ms. Houston.
I've got two questions. The first one is sort of just wondered. On this LC number, I don't think I've ever seen ER on the end. What is the ER made on the end of a LC number?
I've seen that around here, Representative House, ever since I've been here, and I don't know myself.
Okay.
I wish I could tell you.
All right. The next thing I wanted to ask you, line 139, that you have 30 days to notify your creditors.
Yes,
to
ma'am.
Put the assets in trust.
Yes, ma'am.
Okay. Well, why would you notify them, because they can't get it out?
Belt and suspenders, like I said earlier. It was to make somebody feel good about the fact that the creditors not only would have the right to go after that money if you violated what's called the Fraudulent Transfers Act. That's a law that all states have dealing with trust. You cannot hide your money after you owe somebody money. Now, once you put the money in a trust and I go to Banker Williamson and I apply for a loan, I've got to list all my assets and liabilities, and that would include the trust matter. But once I've gotten that loan from him, I would violate something called the Fraudulent Transfer Act if I then tried to put it into a trust. So when I say belt and suspenders, we not only have the protection in general trust law of not allowing me to fraudulently transfer my money to a trust under the Fraudulent Transfer Act, but this also just says I have to notify my creditors as well.
Any other questions for the author of the bill from the committee? Do we have anybody on the sign-up sheet? Representative Williamson, is it, or one of y'all? Reach
I
that?
will share with you, Mr.
And you go ahead with comments. I
Yeah,
mean,
yes,
if
sir,
you do, you
Mr.
have
Chairman,
to
I will
wrap
share
up.
with you, I brought a smart attorney with me, the former president of the Georgia Bar's fiduciary section. In other words, an expert in trust law. In case y'all ask any real hard questions, I'm gonna call him up and would like the chairman to allow me the reserved right to do that in case I get stumped at some point.
So you're saying you want another witness for
Not
you?
yet.
Not yet?
I may call him up later, the chair would allow if we need him, because he can clear about anything. He's a smart lawyer.
All right. For the witnesses, I mean, for the people speaking for or against the bill, we're not gonna have committee members asking them questions. They can say why they are for or against the bill. And it doesn't say here. So, what I'll do is just call these names, and if you're finished your comments right now, and then
Yes, sir.
you can rebuttal if you'd like.
Yes, sir, thank you.
At the end. Thank you.
Thank you, Mr. Chairman, thank you.
Let's limit our remarks to 2 minutes. and Andrea Powiak, did I say that correctly? Oh, okay. Powiak, okay. All right, I'm sorry. Thank you. I won't forget that. If you'll just tell us again who you are and who you're representing. Thank you.
Good afternoon. My name is Andrea Pollack. I'm from the law firm of Schulten, Ward, Turner, and Weiss here in downtown Atlanta. We represent a number of banks and other companies in our work obtain and collect on judgments here in the state of Georgia on behalf of those clients. We handle a number of judgment collection matters from traditional garnishments, charging orders, and levies to fraudulent transfer litigation. And our caseload ranges from small judgment amounts to multi-million-dollar judgment amounts. As we see it, Spendthrift Trust, as laid out in this bill, are an easy way for debtors to keep their assets out of the hands of their creditors. With these types of trust, it is even easier and more attractive to certain debtors to essentially engage in fraudulent transfers to these types of trust, where they can also then be a beneficiary, and while perhaps not defined as a trustee at lines 117 through 119 of the bill, they can be granted the powers to direct trust investments and execute other management powers, not including the ordering or withdrawing of trust distributions. So they do still have management powers under those trusts, under the bill. And so essentially they can be both the settlor, the beneficiary, and the manager of the trust. This bill goes well beyond, I think, protecting assets for your children or other loved ones. This goes to allowing yourself to put your own assets or income into a trust, continuing to use that money on a regular basis. You could essentially fund it and use that to pay your monthly expenses, keeping it out of the hands of your creditors the entire time. And a credit-worthy individual could essentially borrow a significant amount of money, set up a trust such as this, and essentially force a creditor to go the route of filing a fraudulent transfer lawsuit in this state. I think that's well beyond what the trust law should do here. There's also, I just don't think any real need for this type of trust. You've already heard these types of trust or trust to benefit your children or other loved ones can already be done. There's no reason to have a self-settled spendthrift trust to do nothing more than shield your own assets from your creditors. There are other avenues, such as the retirement accounts that we heard about, to do asset planning. The point of the trust, this type of trust, is to prevent creditors from attaching to the beneficiary's interest. What a creditor can normally do under the existing law in Georgia, such as garnishments, levies, and charging orders, becomes impossible once the asset is transferred to such a trust such as this. A creditor, again, would have to file a fraudulent transfer lawsuit, would have additional collection costs, and the court system could potentially be clogged with more litigation over fraudulent transfers when that type of action should not be the result of something like this. One sort of point that I'll make about the Uniform Voidable Transactions Act as well is that a trust is not defined as an insider under that act. And so when you have a transfer to an insider, a trust is not actually defined as an insider. So although there are other avenues to demonstrate that such a transfer would be fraudulent, that particular badge of fraud would not fall within a transfer from a settlor debtor to a trust where he is also the beneficiary of that trust, because that would not be considered an insider as the bill is drafted and as the VTA appears currently. Again, I think there would still be other grounds under the Fraudulent Transfer Act, but that would just expand upon litigation that I mentioned. And there's also a question that we had as to the bill's definition of a qualified trustee. It does not appear to require any minimum contacts within the state of Georgia either. So we believe that the bill should not pass, and we oppose the bill. Thank you for your time.
Oh, thank you, Ms. Ball. Thank you. Russell Love.
This is the fellow I was telling you about, head of the Bar Association.
Oh, okay, all right, well,
Good afternoon. My name is Russell Love. I am a partner with the law firm of Nelson Mullins, and I am here assisting Representative Fleming and to talk about this legislation and how it benefits us. I do understand what the last speaker said is that this is a way, at least a perceived way, to avoid your creditors, and quite to the contrary, that is not the case. It is not intended to permit you to avoid your current creditors. If you are an individual that has no creditors, you are free to plan your affairs and protect from your liabilities. You can put things in, give it away. You can put it in your wife's name. You can buy insurance to protect against that uninsured or that loss that would otherwise be insurable. This is just another way to be responsible and plan your affairs. The belt and suspenders that was mentioned earlier, to me, it's a little bit more than belt and suspenders, where the last speaker was concerned about we have a customer who wants to get out of paying their debt. Well, we're not trying to get out of it. We're going to have to even notify you. So now you're put on notice that if there is a voidable conveyance, then you're on notice to know that you can come forward and make whatever claim you have. Would it incur additional fees? Sure, but if I gave it away to my kids, it would incur additional fees that they would do it. This is intended for someone who doesn't have creditors and merely is trying to plan their affairs to protect themselves. One of the things that wasn't pointed out is they don't have control. They may be able to manage the assets in there, the investments, but they don't have a right to control the distributions, and that's one of the protections. It's one thing to say, give me money when I want it, but this independent qualified trustee, all distributions need to be discretionary, meaning I could be the beneficiary, set up the trust, and be a beneficiary myself. And I have no right to order the trustee to give me any money. He may decide in his fiduciary duty to hold it for the benefit of my children who may be successor beneficiaries. So this is not intended to try to cheat or otherwise bypass liabilities that one may otherwise have. As far as there are other mechanisms, yeah, there's retirement accounts, but they're limited. The federal law limits how much you can put in, either on a pre-tax or a post-tax method. And so you're only limited, if any of you have ever tried to fund your 401ks, you're limited by a certain amount each year. And this is for some people that want to have much better protection once they have satisfied all their liabilities.
thank you, sir. Mr. Fleming, are you satisfied?
Yes, sir.
I know we've got a lot of people with conflicting schedules and want to have as many folks as we could here. Okay, well then if there's no further comments. Well, he said he was satisfied. I mean, and I would entertain a motion. Yeah, well, yeah, do we have copies of that amendment?
I got it right here, and I can give it to council, and I can read it to you.
Read that amendment again, and we will.
What you would
I
do,
wonder
Mr.
where
Chairman,
there's
if you
amendment.
turn over on page 5, you would strike lines 139, 140, and 141, and insert this definition that comes from another part of our code that already exists. Subsection B would read, within 30 days of transferring an asset to a qualified, self-settled spendthrift trust, a settler must give notice by publication of such transfer in the legal organ of their county of residence for his creditors.
Can I have your copy of that you got written down? Thank you. And we strike lines what through what?
39, 140, 141, and replace it with that.
Okay. All right, this is the motion that we would have if there was a motion made to adopt this amendment. We would be again, as repeating on page 5, striking line 139, 140, and 141, and inserting this language, again, within 30 days of transferring an asset to a qualified self-settled spendthrift trust, a settler must give notice by publication of such transfer in the legal organ of their county of residence for his creditors. We've got to move that we accept the motions. Is there a second? No, I thought you said we vote. All right, okay. All right, I got it. All right, let's back up. Yes, we did. Mm-hmm. Everybody signed up. Yeah. Okay, all right, it's my mistake. This is the posture that we are. We vote House Bill 441 as is. I would need a motion, a second, and then a positive vote for that. Assuming we get a positive vote for that, we would vote on the amendment, and then we would have a committee substitute to House Bill 441. Okay? All right, at this point, it'd be a proper time, move to pass. Second. All in favor of the motion signify by saying aye. Huh?
Before you do that, you're not gonna wanna do that. You're gonna say, no, somebody else needs to do the vote for the amendments before they vote, otherwise you pass out the bill as it currently is.
All right.
Now would be the appropriate time to take any motion.
All right, now would be the time to take any motions on the amendment.
Yes, sir.
On the amendment.
So do we have to, I would propose, another amendment if we could consider, do we need to take them both at the same time? Just speaking to exactly what Representative Fleming was proposing, I would just simply urge the committee's consideration of leaving, the language in there, specifically line 140 where it says, shall notify all of his or her known creditors, and then we'd have to wordsmith it, but additionally, I'll put the notice in the legal order of record. That way, it gives clarity to, you know, if you got known creditors, they're being notified, and as the attorney, the trust attorney spoke to, said that wasn't any problem. But that way, you cover both bases. You got known creditors, they're put on notice, and additionally, in the county of legal order of record.
Well, let's don't get ahead of ourselves. Hold on just one moment. Let me make sure I understand what Mr. Williamson is saying.
Basically, leave the intent of 139 to 41 and go ahead in some way, Representative Fleming might help us with the language, also include notice in the legal organ of record.
Mr. Fleming?
Mr. Chairman, could I see the original amendment that I handed up to you, please? To accomplish what Representative Williamson is speaking about, after the word delivery, you would put a comma and then put and by notice of publication of such transfer in the legal organ of the county of residence for his creditors. Now, the only problem with doing that is this, and here's why we changed that, Representative Williamson. If I had a credit card when I was in college, are they one of my creditors? Well, but if you say yes, and I didn't notify the credit card that I had in college, even if I no longer have it, have we just created an ambiguity in the law as to whether or not the trust can be attacked because I didn't notify that credit card? The current law only requires notice by publication like the amendment, and that was the purpose for making the bill similar to current law rather than as it says. Now, we can do what you ask, but just realize you're going to have that side effect.
So if, we're talking about substantial assets, and again, I like the concept of being able to protect assets from uninsured losses, not from a promise
Right.
to pay. And that was, the gentleman testified to that effect, that this wouldn't be a problem. That's not the intent of this. But I would argue that if you had an unpaid, and you didn't even say unpaid, but a credit card in college, but I'm assuming you're talking about an unpaid credit card in college, you're not too worried about maybe settling up with that long-forgotten credit card bill.
You didn't pay the late fee 1 month. Are they still a creditor? Technically, they are. If you don't list them, have you violated this law? Probably so.
I don't know what the statute of limitations on such acts are either.
I suppose it's possible that the author could withdraw the amendment.
I would find that preferable than to pulling back all his or her known creditors. You just suggested he or she did not know about that credit card bill in college. And I think everybody realizes the intent is the known creditors of the financial institutions that it might have extended credit based on character, collateral, cash flow, and sort of in that order. Character, or I should say character, cash flow, and collateral.
So your preference would be to leave it the way it is, Representative
My
Williams?
preference would be.
I'm not going to argue with you.
Is that your, is just to withdraw the amendment?
Yes, sir.
Okay. All right. I'm fairly certain this is the posture we're in now. There is no amendment to House Bill 441. So at this point, I could entertain a motion regarding to House Bill 441. Have a move do pass. Is there a second do pass? There's a second. Any further discussion among the members?
I have a question, if I may. That statement on that line, does that mean every time a deposit is put in that, or is this only constitute a one-time deposit
When you create the trust.
when you create the trust, but can you add to that trust?
Mr. Love?
I think it's every time there's a transfer, which would mean, every time you make a contribution to it. Most people will only do it once, but if you did it once a year, then you would have to do it.
You would have to go through that procedure of putting it in the legal organ.
There you go. He's right.
Parliamentary inquiry, I believe the bill's already passed.
No, we haven't voted on it. There's a motion and a second, and I was asked, is there any further discussion? So there's no clarity, then we could have it. Is there anyone else on the committee that has any comment? Okay, we have a motion and a second. Do pass for House Bill 441. Those in favor will signify by saying aye. Those opposed, would say no. The ayes have it.
Thank you, Mr. Chairman.
Do
Appreciate
pass
your help.
recommendation from the committee.
Mr. Chairman, can you wait 2 seconds so I get you to sign this?
Yeah.
How do you deal with
Sorry, I got backwards, you know, but I was, he was right.
yeses, no nos?